The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon and welcome to today's webinar. My name is Amanda from CCIQ and I'll be your facilitator for today. Joining us is Jacinda Davies, one of our HR IR specialists here at CCIQ. Now before I start today, I'd just like to make mention of today's webinar sponsor, CIVS. They are an independent online voting solution and they specialise in enterprise agreements. Our employee assistance team receives more than 500 calls every month from businesses seeking advice. So with such a high volume of calls and a wide variety of knowledge, it's pretty safe to say that there is not many issues our employee assistance team haven't heard before. Now today, Jacinda is going to provide an insight into the 5 most common HR mistakes businesses make and some simple cost-free steps that your business can take to avoid them. Before we start, if you want to ask Jacinda a question, you can do so at any time during the webinar using the chat box that appears in the bottom right-hand side of your screen. So I'll now hand over to Jacinda to take you through today's presentation.
Thanks, Amanda. Hi, everyone. Thanks for joining us online for today's webinar, that being top 5 common HR mistakes and how you can fix them. So when we were developing this webinar, the team and I did sit down and have a chat about what most recently we've seen being the main issues for businesses in regards to HR mistakes being made. And these are the topics that we came up with. So the agenda for today, we are including a bonus topic, which we would consider the most common mistake, I guess, for us and why it's so important. Today's webinar will include scenario examples. I'll draw on some of my personal experience. We'll talk about some calls from members that we've had, and we'll wrap things up with a case law example too. At the end, I'll also go through information on the free resources that we'll provide in addition to today's webinar. So the most common mistake that we do see employers making is to forget about their registered agreement. So this is so important when considering that an enterprise agreement or collective agreement may have terms that are different to modern awards, for example. So this is important for us when we're providing advice to businesses so that we can ensure that the information we're giving is correct for the employee circumstances. So I've just put a little disclaimer in this slide, and that is that all information in this webinar is general in nature, so we haven't taken into account any of the specific details that might be in registered agreements, except where we've noted. If you're not sure if your organisation has a registered agreement, you can go online to the Fair Work Commission, and they do have a document search capability where you can put in your company name and you'll see any registered agreements come up there. So our first topic that we're going to look at today is recruitment checks. So there is a lot of information out there on the cost of hiring employees, not just the direct costs such as advertising, but also other costs including lost time due to shortlisting, interviewing and reference checking. Obviously, recruitment can be quite a lengthy process. Average hire time is usually 50 or 60 days, but also the strain on an existing team when there is a shortage of employees. That's why it's best to have recruitment checks in place to ensure that turnover is reduced and you're choosing the best candidate for the role, ensuring you're meeting your obligations as an employer. So we've just put together a table here of some of the minimum checks that should be completed throughout your recruitment process. I would say that the most important of those is checking Australian work rights. I have been shocked at the amount of people that don't do this check. It's so important in this day and age with such a diverse culture in Australia, so many different people, that we really should be checking that people do have the appropriate work rights. And you can do that online through Vivo, which is Visa Entitlement Verification Online. And you can put details in there of international passports or non-Australian passports, and it will immediately identify whether or not that person has the right to work in Australia, as well as any limitations on that person's work rights. So we've also included in here that you can verify birth certificates, so that's meaning Australian birth certificates. You'll see here we've also included marriage certificates and other legal change of name documents. That's important. We'll discuss that shortly as to why. Reference checks are important, obviously, that you want to verify work history and experience that any candidate has told you that they have. And also any specific industry checks, which could make reference to legislation or industry regulations. And again, making sure you check those registered agreements for any specifics on your recruitment process. So here we can just see some of the examples that I've already discussed. Obviously, the best way to make sure someone's got Australian work rights is an Australian passport. That's because it has a photograph of them, so you can tell that it is that person. And obviously, it evidences that they are an Australian citizen. We've also got Australian birth certificate and photographic ID, and this is where the marriage certificates that we were just looking at come into play. So a lot of the time you might get a birth certificate, for example, that says Bob Jones, and then you might get a driver's license that says Bob Smith. So because of that change in name, you do need to verify that it is the same person. That's when you'd be asking for a legal name change document, marriage certificate or other, that shows how that name change came about. On the right here, I've just put together a summary of the penalties which I've pulled from the Department of Home Affairs website. Obviously, there is some pretty significant penalties there in regards to hiring people that do not have the right to work in Australia. So a very quick check that you can do and something that's very important to the recruitment process. Moving on now to recruitment checks and reference checks, here's just a couple of tips that you can follow to authenticate references, companies and referees. So if you're not sure about a business or a person that a candidate has provided, ask the candidate to give you more information. So let's just say employee or candidate A provides you with a phone number for John from John's Lawn Mowing and you've never heard of that business before. Ask the candidate about it. Where are they from? Where are they located? Are they online? And you can do that too. You can search for a company online, see if they exist. And the great thing about that too is that some companies do actually list their teams, and that's how you might authenticate that that is a real person that you're going to be speaking to, by seeing the name in the team list. So there are some resources that say that you could also call the company the employee has advised you the person is from and ask to speak to them, rather than calling on the details that the candidate has provided to you. We like to encourage transparency. So we recommend that you ask that candidate, if I called that business, would they be able to confirm that this referee works there? It's a great question to ask to make sure that that person is providing you with contact details of an actual referee and not just their friend or relative. So I've put on this slide as well my ultimate question, which is, would you re-employ this person? So my background, I was a recruiter prior to entering into a HR career, and I can't even tell you the amount of times that I would do reference checks that would sound good or even great, and I would get to this last question of, would I re-employ this person, or would you re-employ this person, only to have them answer no. Even though the reference check questions that I were asking were quite comprehensive in regards to that person's skills and abilities, there would be other reasons that just didn't fit into the questions I'd asked that led that person to believe they would not rehire that person into their business. There was reasons for that, and you can definitely ask the question why. You know, some people had changes in attitude or enthusiasm. Maybe they didn't respond to significant organisational change too well. Even instances that occurred post-employment, so maybe a failure to provide company property or return company property. A lot of different reasons that make this a great question to ask when doing reference checks. So on this slide, this is where we're talking about some of the industry regulations that might be in place, and these are well worth looking into. So on the left here, we can see some industries that would typically have requirements for additional checks, and on the right, some of the additional checks that might be required. So Starting off at the top, you can see transportation and delivery services. One of the checks that you might do there, let's say, for example, you're hiring a truck driver, you might want to see a traffic history report. Something that's not outlined here, which is aged care, which might fit into medical if you were looking at employing aged care nurses. You'd need to give regard to the Aged Care Act, which is legislation that outlines provisions regarding suitable persons, meaning that a police check would need to be completed. So it's a good one to look into. We've basically had the commission recently into the finance industry, which has resulted in some regulations that some banks are now following in regards to their hiring practices as well. So definitely interesting and well worth looking into in regards to your specific industry. So the first of our scenarios, we've got a scenario here where the employer has been provided with a copy of the forklift license that has expired. Obviously the one on the right here is the old style Queensland high-risk forklift license, whereas now the one on the left is what should be provided. The employer hasn't thought to ask or check that they have a current and valid license, and they say, well, that's good enough for me, and let them loose on a forklift. There's then an incident where that employee is operating the forklift and they injure someone while they're working in the warehouse. So while it's definitely a good point that the employee should have advised that the license was expired, or it's their responsibility to ensure that that license was renewed, employers do have an obligation to ensure that persons who are unlicensed don't operate machinery, and they should have requested evidence so that they could determine that. This slide is just looking at some of the privacy principles. So some candidates and employees do express concern about collection of their personal information. Obviously, where we've provided that advice that you should be doing the Vivo checks and checking people's ability to work in Australia, it does involve the collection of some confidential documents. The privacy principles do outline that you should let an employee or candidate know how their information will be collected, used and stored. And of course, all employee files should be kept secure, and employees should not be able to access those files unless they work in HR or they're a manager that should have access to those documents. So when people do raise those concerns, you can provide them with that reassurance by letting them know what their information is going to be used for, and that is just to verify their work rights. And you might let them know that you'll either destroy the document once you've used it for its purpose, or that you'll retain it in the employee file. That brings us on now to our second topic, which is parental leave. So the reason we've included that topic is that a lot of employees don't think about parental leave until someone has already left their organisation to have their baby. So we're just taking a quick look here at the Fair Work Act. On the left, we've got Section 70, and you can see that there's no reference to gender of employees who can take leave. Here in subsection B, you can also see that regard is given to the employee that has or will have responsibility for the care of the child. So male, female, it doesn't matter. All it matters is who is going to have responsibility for the care of that child. On the right, Section 72, this is for employee couples who intend to take leave. So here we can see specific reference is made to females and the 6-week period prior to giving birth. We'll touch on that in a bit more detail soon. If the employee is not the pregnant female, you can see there that the period of leave starts when the baby is born. Now, this is just some really brief information as to who's entitled to parental leave. There is a lot of detail in the Fair Work Act in regards to parental leave. And of course, there can be different circumstances, so well worth looking into if needed. Some of the obligations and guidelines that people should follow, and this is 10 weeks prior to someone going on unpaid parental leave. Asking the employee to provide you with notice in writing of the last working day, the start and end date of the leave that they're going to be taking, and a medical certificate confirming the expected due date of the child. So most people just say, well, I can tell that this person's pregnant. Well, you should still seek to get that medical certificate to confirm when that due date is. And you can, of course, request that from a male employee when they're seeking to take parental leave also. Now, this 10 weeks where they're providing information, obviously a lot can happen in the last 10 weeks of pregnancy. This can absolutely be adjusted where needed, and employees should just seek to provide updated information where relevant with any renewed details. Most importantly, and it is covered under the Fair Work Act, is the guidelines in the 6 weeks or the final 6 weeks of a person's pregnancy. So there are other requirements in the Fair Work Act, such as transferring to a safe job. We won't go into too much detail. Obviously, the legislation is quite lengthy in that regard. But this 6 week is quite important to note because employers should be seeking to get a medical certificate from the employee, letting them know that the employee is fit for work. And if they are fit for work, that it is advisable that they can continue in their current position, giving regard to any hazards associated with the position, any other risks that might arise considering the employee's pregnancy. We get a few questions also on the Australian Paid Parental Leave Scheme, so that is through Centrelink. And we've just got some steps here that you can take, and also we've included the link on this slide that organisations can follow so that they can register online. It doesn't take too long at all. Not that I had to register Chamber of Commerce, but I did go online just to navigate to see what it's like from an employer perspective. I found it quite easy to navigate through and find what I needed to. Just included some bullet points at the bottom here. A lot of people get confused with their payroll obligations because Centrelink will distribute the funds to be paid through payroll. So yes, you should withhold tax on these payments for parental leave and withhold any deductions required by law, typically child support payments there. And you don't pay superannuation on paid parental leave payments. So Centrelink also provides parental leave payment or dad and partner pay, and there's also another link there. It is slightly different. I believe that you can still run this through your payroll. However, Centrelink does tend to pay this directly to the dad or partner. So we've got here some flexible work arrangement considerations. I'd have to say this is one of the key considerations we see businesses fail to make. And that is that when an employee is leaving, they're going to have their baby and they have every intention of coming back full-time 12 months after they leave. Not everything goes to plan. Life changes within the space of 12 months, particularly when you've had a child. And it is important that employers keep this in mind when they're expecting that employee to return, because that employee can request a flexible work arrangement to be made. So we've just put some tips up there, just some things that we've assisted employers with where they haven't thought of these sorts of things. Working from home, allowing them to work part-time. And that last one there's a good one. Sometimes people might just need a bit of an adjustment period after having such a long time off work that they just want to work 4 days a week for a little while. In that instance, an employer might allow someone to use their annual leave on the Friday of each week, for example, for an agreed upon period to let that employee adjust back into the reality of working full-time. So we put together some recommendations here for you. This is a good one to keep just as your own reference. Of course, including the parental leave process in your leave policy is a great starting point. Reason being, we don't see people taking parental leave as often as we see people taking annual leave or sick leave, as an example. So it's a good reminder, not just for employees, but also for employers as to what the process is. Ensuring you refer to those 10-week and 6-week guidelines. Communicating with employees who are on parental leave. This is an important one. When you've got employees who are absent from the business for such a long period of time, it is nice if you just touch base with them occasionally. You can do that by giving them a call. You might send them emails, and you can still, of course, invite them to social activities, particularly where there might be changes in the business as well. It is always a good idea to just touch base with those employees, and have a chat and let them know what's been happening. Remembering that the employee is legally entitled to return to the same job they had before taking the leave. And of course, as we've discussed, considering flexible work arrangements for employees returning. So as I said, there is a lot more in the Fair Work Act in regards to parental leave. These are just some of the issues that we've seen employers have. You do have to give regard to whether the person is entitled to the parental leave and a lot of other factors. So definitely a case-by-case basis for the information provided. Moving on now to my favourite topic, and that is personal or sick leave, being my favourite because this has to be something that I discuss with members at least once a day. This is my favourite slide in particular. Reason being, it's a great thing that employers can use to make sure that the person that's issued a medical certificate for an employee is actually a medical practitioner. So follow that link there and it will send you to the site that I've included on the screenshot on the left. You can enter the practitioner's name who's issued the medical certificate, search them, and it will show up as to whether they're a medical practitioner or not. The reason that I'm pointing that out is we do get a lot of people questioning, I've been provided with a medical certificate from an employee's dentist or physiotherapist or some other sort of allied health professional. The AMA guidelines are pretty clear that it should be a medical practitioner issuing a medical certificate for these purposes. So those allied health professionals, they're more there to assist post-injury most of the time, or maybe helping with some preventative things. They're not a medical practitioner skilled in identifying whether someone is fit for work or not. Okay, so we do have our second scenario here for the webinar, backdated medical certificates, another very popular question. So employee was absent from work on the 23rd of April. They provide you with a medical certificate dated 24th of April, so issued by the doctor on the 24th, declaring the employee was unfit the previous day. Do you have to accept this? So essentially, do you have to accept a backdated medical certificate? The answer to that one is yes. So the only time there would be an issue is if a doctor issued a medical certificate today, but dated it as yesterday as them issuing the medical certificate, which most doctors would not do, or all, I should say. What they can do, though, is review an employee and determine that they were unfit for work the previous day. So I'm sure we've all been there when we've had a terrible flu or some other illness. We've been stuck in bed, and the last thing we can do is get out of bed to go and see a doctor. The next day, you still might not feel too well. That's typically when you'd go to the doctor, when you are capable and ready to go, and you'd say, look, I was in bed all day yesterday. The doctor would examine you and they will come to the conclusion as to whether or not you were fit or not the previous day. So yes, they can actually provide medical certificates that cover previous days. Just an important side note here that I did take from the AMA guidelines as well, and that is that medical certificates are legal documents. So we do get a lot of people questioning doctors' certificates, we don't believe them, or we're not sure why a doctor would have issued this person with a medical certificate. It is important to remember, like I said, they are legal documents, and doctors who deliberately issue false, misleading or inaccurate certificates would face disciplinary action, and it's not likely that they would do so by issuing a medical certificate. In saying that, we do know that people out there do produce fraudulent medical certificates, employees. So this is something that we've helped employers with quite a few times. And this slide's fantastic for helping you with what you can do if you suspect that you've been provided with a medical certificate that is fraudulent. So some of the examples that we've had from employers we've spoken to include forged names on medical certificates. So I think one example was husband and wife that had the same surname, and they amended the medical certificate. One went to the doctor and got the medical certificate, and they amended that to suit the other as well. Dates being changed on medical certificates is a popular one. So A doctor may have said that someone was unfit for work for one day and someone's forged the date so they can have that extra day off and get paid their sick pay. In both of these instances, the employer was able to confirm by calling the medical centre and the treating doctor issuing the medical certificate that the details provided on the medical certificate were not correct. So it's not a breach of privacy for employers to do this, and it's actually something that we'd encourage in the instance that you do think you've been provided with a fraudulent medical certificate. All you do is note the practitioner or the medical centre that the employee went to, and you give them a call and say, I'm an employer and I would just like to verify the information on this medical certificate, and they'll confirm or correct if you've been provided with incorrect information. So the reason that some employees may say that it's a breach of privacy, obviously you cannot inquire about that employee's medical condition, and a doctor won't provide you with that information without the patient's express consent. So the whole purpose of what we're getting at here is very much just to check the legitimacy of the information on the medical certificate. We're not looking for any extra information as to whether that employee was sick, and if they were, what was wrong with them. So we've included a table here. It's sort of a scenario question, but this is a good one to have as well. It is a common mistake we see people make, and that is where an employee's been absent on sick leave and they haven't provided their medical certificate. Payroll has to close. It's all very urgent. And they say, well, we don't want them to miss out on money. We know they've been so ill. Let's just process it as annual leave. That shouldn't be occurring unless that employee has specifically requested their annual leave be used for that reason. So if you do find yourself in this situation, you can make a call, your management team can make a call. You might decide that you will process it as sick leave without the required documentation. I'd recommend caution with that. You might be setting a precedent. You would be referring back to your policy in this regard. Typically what we'd recommend is that you process it as leave without pay, as payroll might have to close and it might be urgent, but that employee is not well. They might just provide you with a medical certificate at a later date. You can then process it, do some sort of amendment to your payroll. So we're moving on to our fourth topic now, and that is paying employees during stand down. So the reason that we're discussing this, obviously we had the extreme weather event up in Townsville earlier this year, and this led to quite a spike in phone calls in this area and a lot of uncertainty in regards to what employers should do when they're standing down their employees. So here we can see in section 524 of the Act, employers do have the ability to stand down employees in certain circumstances. So under the Act, they've outlined industrial action other than that engaged in by the employer, breakdown of machinery, and a stoppage of work. Keywords there are for which the employer cannot reasonably held responsible. However, and this goes back to that first bit of information I provided to you at the start of today's webinar, and that is giving regard to your registered agreement. So on the left here we can see in section 524 of the Act it does give regard to enterprise agreements, and I've just included on the right the sort of phrase that you might find in an enterprise agreement where you wouldn't refer to the Act. So as discussed at the beginning of the webinar, it is important to refer to these agreements. This agreement does show that the employer has to provide some notice and allow options for the taking of leave. And agreements might have additional terms as well. There is a multitude of different agreements out there written all different ways to suit different organisations and their employees. So definitely important to check in case there is any further restrictions or instructions that you should follow in the event of a stand down. So we've provided a handy table here for you as to whether stand down should be paid or unpaid. So of course this is not giving regard to agreements again. As we've discussed, industrial action, breakdown of machinery and stoppage of work for which the employer cannot be held responsible are unpaid. Now I've just included in the bottom here, employees suspended during investigation. So while that's a very different topic, a lot of people, myself included, tend to use suspension and standing down interchangeably, which can lead to some confusion. So any suspension of an employee for purposes of an investigation, for example, is not classified as a stand down for the purpose of not paying an employee. An employee suspension, they should be paid, and it's treated very separately. I've just put that in there, like I said, because those two terms do tend to be used interchangeably by some people. So what we haven't included and what's not outlined in the Act is the extreme weather events. But what you're looking at here is anything that's extreme and outside of the employer's control. Okay, so we have another scenario. We have here employee A is contracted to work 38 hours per week, Monday to Friday. Business has been quiet recently, so you want employee A to work 30 hours per week until things pick up. Is it a stand down, and should the employee be paid? So when we're looking at whether it's a stand down, the answer to that one is no. Reason being, this is a decision that the employer is consciously making. It's not out of their control, and it's something that they're just deciding to do. Should the employee be paid? Yes. So they're contracted to work 38 hours, and the employer must acknowledge their obligations under that contract. So we have seen employers, when times get slow and they've got people contracted to work 38 hours a week, they say, well, we'll just get them to work 30 hours a week. They can have a day off and we'll just pay them for the 30 hours a week. That doesn't work, because you have contracted them to work 38 hours. You're telling them to take a day off. You need to pay them for the 38 hours. The only exception to that rule is where you had a mutual agreement between employer and employee to have that day off without pay, or to take some sort of leave would be what would generally happen. On to our final topic, and the importance of this topic means we have left it until last. My favourite quote, make sure you get it in writing. So what we're going to focus on here is in regards to the new onus of proof laws. But before we get started on that, just reiterating the importance of keeping all records, particularly records of conversations. A lot of people do reach the point of wanting to terminate an employee and have failed to keep records of discussions where they have addressed that employee's performance in the past. But for this section, what we're going to be looking at is Section 557C of the Fair Work Act. So this was introduced in September 2017. Employers who don't meet record keeping or payslip obligations and can't give a reasonable excuse will need to disprove allegations in wage claims made in a court. This is sometimes referred to as the reverse onus of proof. So if an employee claims there is a breach and the employer didn't provide the right records, make those records available, give the employees a pay slip, then the employer needs to prove that they did pay the employee correctly or gave them the right entitlements. So we do have a case study that we're looking at. As far as I'm aware, it is the first case where Fair Work has used this new law, and that is Fair Work Ombudsman v A&K Property Services. A&K are fast food sushi operators with outlets in Ipswich and the Sunshine Coast, and they were audited by Fair Work inspectors due to alleged breach of workplace laws. It was found that they'd failed to provide pay slips or proper time and wages records, underpayment of hourly rates, weekend rates and overtime rates. Employees hadn't been paid superannuation, and annual and personal leave entitlements were not accrued. So what would happen in the past is that employers would avoid litigation when sufficient evidence couldn't be proven. This new burden of proof legislation means that employers are responsible for the onus of proof. So I guess if we're going to rely on some American drama series terminology, where it may have been you were innocent until proven guilty, is now no longer the case. The onus is on the employer to prove that they did the right thing. And what we can see in instances like this is where you're not able to, or you attempt to provide information and it's actually reconstructed. There's some pretty heavy penalties that are going to apply. So like I said, this is the first case that I know of that Fair Work is actually enacting this new legislation. For anyone that's interested, definitely keep a note in your diary for the 16th of August 2019. That's when they've adjourned the penalty hearing until. So that will be an interesting one to see what happens there. Okay, so that's the end of our webinar today. I was just going to take a moment to go through quickly some of the resources. Hopefully this is something that you're all interested in, is the free resources that we'll be sending out. So we've got a recruitment checklist, reference check templates, leave application forms, and a couple of other things there for you. They've all been developed to assist employers that have registered for today's webinar to assist and complement the information we've provided today, and they'll come out to the email address that was used to register for the webinar in the upcoming week. We've also got some paid resources available at Chamber of Commerce. So we do HR health checks. 2 hours, we can come and visit your workplace. Sometimes we'll do them over the phone, but they're a great way to check that you've got all of your minimum requirements in place. We now have our regional partners, HR Dynamics, based in Cairns, who are available to conduct these to businesses in the Northern Queensland region too. So there's just an overview of some of our employer assistance services. I'd just like to acknowledge that we do have the free workers' compensation helpline funded by Office of Industrial Relations. So this is something that you can use whether or not you're a member of CCIQ. You can provide that phone number to any business that you know. They can call us and get free information on workers' compensation. We'll answer any questions regarding the process, rehabilitation and return to work, case reviews, appeals, and any other information that's needed. Like I said, it's provided by CCIQ for all businesses in Queensland, so feel free to tell other businesses about it too. Employees can access free information on the workers' compensation process too through the Queensland Council of Unions. And something that some employers might be interested in is they now also offer the Workers' Psychological Support Service, which is a great initiative where employees that might be experiencing some psychological issues can actually make contact. So we might provide those details in our follow-up email for you as well, in case you've got employees that would like to access that. All right, so thank you everyone for attending. We will get into some questions shortly. Just before we do move on to that, some details here on how to become a member. You can jump online to the membership page. We now offer monthly memberships and they start as low as $60 per month. Just another reminder, don't forget to like our Facebook page. So we've got two, Chamber of Commerce and Industry Queensland is HR and Industrial Relations. So you can see all of our upcoming webinars like the one you've just listened to today. We've also got some really useful HR information on some great topics as well. We've also got the Chamber of Commerce and Industry Queensland page. You can see some of the great work our advocacy team is doing to support small businesses in the lead up to the election. And grab yourself a Small Business is a Big Deal free promo pack, which has been developed by CCIQ in conjunction with the local chambers. All right, so we'll just look at some of the questions that have come through from Amanda.
Excellent. Thank you very much, Jacinda. Yes, we have received quite a few questions. So I've got a few on the stand down topic. So first one, if an employee fails a drug and alcohol test or refuses to do a drug and alcohol test, can you stand them down without pay?
So this is going to depend on the policy that you have in place. So if you're doing drug and alcohol testing, it should be outlined in your drug and alcohol policy what the process is. Speaking very broadly, typically refusal or failure to provide a sample would be considered a non-negative result. So it would be treated the same as receiving a positive result. Again, you would need to refer to your policy specific to your business.
Okay, and when you were speaking about when an employer cuts down someone's hours, what if you actually are giving the employee 4 weeks notice that you will be decreasing their hours? Do you still have to pay them?
This one would probably depend on your award or your agreement. I guess the information that we have provided today is quite general in nature. And what we were getting more at there is some employers that don't acknowledge that there is a contract in place that they should be ensuring that they fulfill, even though business might be slow for them. There's definitely things that you can do with consideration to the award or agreement that might govern your employee's employment, and I'd recommend looking into that further to see what you can and cannot do.
Okay, for a general company, what rights do I have to request a police check? Just a general, like not a industry specific.
Yeah, sure. I guess my first recommendation there would be determining why you're asking for the police check. So probably something really important to discuss is that the use of police checks shouldn't be to, as I've heard employers say, improve the calibre of people working for your business. They should be there for a reason. It can be considered discriminatory to not offer someone a role based on the results of a police check where it's not relevant to the inherent requirements of that role. So as an example, you might have someone that is applying to be a receptionist of an organisation, no access to anything else, just a reception role, and you ask that person to do a police check. When you receive the results, you notice that the person has actually had a drink driving conviction. If you were to determine that you're not going to offer that person the position based on the results of their police check, it's likely going to be discriminatory because you don't have a requirement for that person to operate a vehicle. So it is an important one to have a look at, that you're not being discriminatory in the use of police checks.
Okay. I have seen signs at pharmacists where they offer to provide medical certificates. Are these acceptable?
Yeah, that's a good one. Again, I guess that's why we've included the slide where you can actually put the practitioner details into the medical board website. If you've got a pharmacist issuing a certificate, unless they are a medical practitioner, I probably wouldn't accept it. If it is issued by a doctor, yes, you should accept it. In the AMA guidelines, it does advise doctors to refrain from participating in provision of online medical certificates and such. I guess that does still happen, so that's a good web page to go to and have a look. Something else that we didn't mention is, I guess, employees may try and provide you with a stat deck. That is something that could be acceptable to the reasonable person. If you wanted a medical certificate, I would suggest that you should add that into your policy and make it specific that you would like a medical certificate to be provided.
Okay, I like to stipulate to my staff that doctors' certificates are required for sick days taken on Mondays and Fridays. Is this allowed?
Yeah, you can definitely do that. So pretty much any time an employee is absent from the workplace, you can request evidence that they were not fit for work. So whether that be them providing a medical certificate or a stat deck. Reason being, you are paying out a paid leave entitlement. So you're entitled to ask for that for any absence from the workplace. And again, it does depend on your company policy or any agreement that you might have in place. So make reference to that. But yes, that's definitely something you can do.
Can we backfill someone's role while the employee is on parental leave?
Yeah, you definitely can, and most employers should. What I would recommend, and this is probably another common mistake that we see, is that employers might have a full-time employee going on parental leave, and they think, well, it's a full-time role, so we need someone full-time, and they employ someone full-time. Well, what are you going to do when your employee returns from parental leave if they want to come back to a full-time role? They have a legal entitlement to come back to that full-time role. So what we recommend doing instead is looking at a fixed-term contract. That way it can be extended if needed, if your employee does need that extra bit of time off. Or you could look at putting on a casual employee.
Okay, moving on. Where do I find more information on Vivo?
Okay, we haven't actually put a link to that in our slides. So that is definitely something we'll include in the follow-up information that we send out to all of our attendees today. It's free to use. Not sure if I mentioned that previously. Very easy to navigate, but I'll include a link that takes people directly through to the organisation page where they can register their organisation. From memory, you're just going to need a point of contact and your company's ABN.
Okay, what happens, or can you provide some advice around employees that do provide medical certificates, but they're always from a different doctor or doctor centre, medical centre?
So where we see trends occurring where employees are taking, let's say an employee is taking every Monday off, that's something I would recommend having a conversation with that employee, acknowledging that trend. So as we mentioned, those medical certificates are legal documents. I'd be hesitant to suggest that you would question a treating doctor's professional regard to claiming someone's not fit for work. But by all means, I would absolutely be identifying with that employee that they are taking certain days off work where they are always sick, and having an open and transparent conversation to determine if there's any other issues that might be underlying. So from experience, sometimes it could be that someone is working on a very intensive project and they feel like they might benefit working from home one day a week, or they may be experiencing some personal difficulties, so they would like a bit more flexibility with their work arrangements. It's all about having that open and transparent communication to determine why that's happening, and that way you can start to address it.
Right, I think we will wind it up there. We have had a couple other ones that are a bit specific, so we'll take them offline. Thank you very much, Jacinda, for presenting today. Thank you for everyone who's joined us. Once again, thank you to our webinar sponsor, CIVS. They also have an exclusive offer for today's webinar attendees, which we will send out to you in the follow-up email along with more information. We'll also send links to the resources that Jacinda mentioned, plus a copy of the webinar recording and presentation slides. Also, check our events registration page because we have some more webinars coming up in the HR/IR space. Tomorrow's webinar on suitable duties, if you had registered for that, has been postponed till the 18th of June. We also have another webinar revisiting the enterprise agreements on 22nd of May, as well as employee contracts on the 20th of June and modern award changes on the 3rd of July. So we'll send out links to them. Make sure you register for them. Thank you for joining us, and on behalf of CCIQ, we hope you enjoy the rest of your day. Thank you.